p.m.
Hello, I am hoping you can hear me. Can you please let me know if you can hear me? We're expecting a lot of people today. I'm very excited. Nicola, you can hear me? Very great, excellent. Well, now that you can hear me, as people trickle in, I'll get started. Thank you, Anne. Great to see you here. Thanks everyone for registering. Really hit a nerve with this topic, I think, because we have a lot of registrations, about 4 times more than we usually have at about 400. So it's a hot topic, and I don't want to prattle on too much. I'll let you get into the material. So last webinar we did have an issue with the sharing of the screen. The share, Tammy, great, you can hear me from Cranbourne West. Very happy to hear that. Can you see me flicking my slides? Let's make sure that's working, because about halfway through last time we worked it out. Okay, great, excellent. We've got the tech check done. Hello, everyone. Welcome. Thanks for joining me today. My name's Sarah Bartholomeusz. I'm the principal of uLegal, a law firm that specialises in helping medical and health practices with compliance, risk management and governance. And I'm really excited to have you with us for this 30-minute webinar. We know how busy you are, so I wanted to keep this session practical and focused on the key things that you need to know, because there's a lot of change happening in our space, as we know, but this one is critical for all health providers. And I know you'd be disappointed if I didn't start with a disclaimer, because I know many of you have asked some really good questions when you registered, but this presentation is going to be for general guidance only. Legal advice in relation to specific issues do need to be separately given with the full context. And even in reviewing some of these questions, I was thinking we need more context on this. So you'll have the opportunity to book a complimentary call with either myself or one of the senior lawyers in my team, Daniela, at the end of the webinar. So we will get onto that soon. For those of you I haven't met, I thought I'd do a quick intro. My name is Sarah Bartholomeusz, as I said before. I started uLegal, my law firm, 12 years ago next week. Can you believe it? It has been really an amazing opportunity for me to be able to tap into an area of law and cohort of clients that I really care very deeply about, because I come from a family of doctors and other health professionals. And so taking care of and protecting medical practices is really very personal to me. And I also have I guess the privilege of being able to say that what I do every day helps, and it helps protect the health of all Australians in protecting people's medical practices as well. So very, very happy to be working in such a meaningful area. I also have written this book, Growing a Medical Practice. I've written 3 books on governance. This one is probably the most relevant to the people on this call. It's available from our website if you haven't seen it. It's a great guidebook for people who are starting or growing their medical practice and want to do it in a legally compliant way. So I'm hoping most of the 400 people on today's session are interested in that, and that's why you've signed up. So let's get started. Whether you're a small or large medical or health practice, you do need a privacy policy. And I talk to people every day who don't know that. So that's why I'm starting with why this matters. That is the number one reason why this matters. You need a privacy policy. No questions. And that's because you deal with sensitive patient information every day. And it's really one of the reasons that this topic is so important. The Privacy Act mandates that people who deal with sensitive patient information need to have a privacy policy, and it's really central to your patient trust as well. When a patient walks into your office, they're not just trusting you with their health, they're also trusting you with their most sensitive personal information. And if that trust is broken, it can have long-lasting effects on your reputation and your ability to deliver care. So it's the law, you need a privacy policy. And if you have independent practitioners, which many medical and health professionals do, they also need their own independent privacy policies because they run their own business from your location. You've seen it in the groups, so many discussions about tenant doctors and independent practitioners. They're independent, which means the Privacy Act requires them to have their own privacy policy. As some of you might know, there have been some major reforms to the Privacy Act, and that's why I'm running today. The changes are called the Privacy and Other Legislation Amendment Act 2024, and so that's also known as POLA, as you can see, that's the acronym for it. These reforms have been designed to strengthen privacy protections and make the obligations clearer. They increase accountability when it comes to management of patient information, and the consequences of non-compliance with this act now are significant. We're talking about very hefty financial penalties, reputational damage, and regulatory action. And this is something I'll go into a little bit more because I know it's interesting to me as someone who also runs a business with sensitive information. So I thought it would also be interesting to you as well. So most of these changes actually became effective on the 11th of December. But there's also been the new statutory tort, which I'll talk about as well, which came into effect on the 10th of July, and some are going to come into effect in 2026. So I thought now might be a good time to update you all. So here's a brief overview of the reforms. Firstly, we have much stronger obligations around how sensitive health information is handled. It's no longer enough to have a policy just sitting on the shelf. Regulators expect real systems, training, and security measures being in place. I'll discuss some of the practical changes with you that you might need to implement soon. Secondly, there's a new tiered civil penalty system with a range of penalties for both serious and mid-tier offences. There's also a new statutory tort, which I just mentioned, for invasions of privacy. And a tort exists where there's no contractual relationship between people. So you can be liable for negligence even if you don't have a contractual relationship. And what this means is someone can sue your practice if they believe, for some reason, they're not a patient, or if they are a patient, they believe their privacy has been seriously breached. So, for example, if their records were misused or inappropriately disclosed. There's also a criminal offence for doxing, which is up to 7 years imprisonment, so a significant offence. What doxing is it's the malicious release of personal information online and in a harassing or menacing way. So while it may not be common in health or medical industries, it does serve as a reminder to safeguard patient data against unauthorized sharing, especially on digital platforms and on social media. I'm not going to deep dive into this change, but I just wanted to bring it to your attention. Oh dear, now all my slides are going haywire. Sorry. Got this new mouse that my physio suggested because I'm on my computer so much, but sometimes it goes haywire. All right. Why organisations must also update their privacy policies to disclose their use of automated decision making. So some of your questions related to AI, and some practices might be using automated decision making, including through AI, in your practice. Importantly, the Office of the Information Commissioner has now expanded powers to investigate and take enforcement measures. It's really something that the government is taking very, very seriously. Now, this is probably the primary one that is relevant to health and medical providers. Under the Australian Privacy Principles, APP 11, APP entities need to now take reasonable steps to protect the security of personal information. Following the reforms implemented by the POLA Act, these reasonable steps include technical and organisational measures. Technical measures could include encryption of sensitive information and the implementation of multi-factor authentication techniques to minimise the risk of unauthorised people getting access to your practice's IT system. Organisational measures could include training staff on privacy and data security, restricting staff access to clients' personal information on a need-to-know basis, and promptly disabling accounts of former employees or contractors. It is essential that you update your privacy policy to reflect these new standards. I mentioned the statutory tort twice, and this new tort exists for individuals who are seeking redress for serious privacy breaches, which relate to intrusion into personal seclusions or misuse of personal information. This tort applies to intentional or reckless invasion, such as unauthorized disclosure of patient records. And one thing I often talk about in privacy trainings is making sure that you have confidentiality agreements, maybe with people that you haven't necessarily thought about having them with, like specifically with your IT people, with your cleaners, in case there's something that's left around that could be of interest to them. And we've seen that with clients in the past, if they've had maybe high profile patients that people have seen around in the waiting room, that their personal information, sensitive information, can be particularly interesting to people who may not work for you. So keeping in mind who might have access to that information, even incidentally. So for practices, it means a patient could pursue legal action if their personal information is mishandled, potentially leading to compensation or injunctions. Courts will assess factors like the degree of distress caused, the seriousness of the invasion, and whether there was a reasonable expectation of privacy. There are several defences and exemptions to this tort. For example, if the defendant acted with consent or with lawful authority. This tort came into effect on the 10th of June 2025. So not very long ago. The civil penalty provisions. So one of the most significant reforms is the expanded powers of the Commissioner, and this includes the ability to offer serious infringement notices and compliance notices. So this is the regulator essentially, and we know now they're being much better funded to be able to take this action. They can impose serious penalties for breaches. There are mid-tier and low-level civil penalties that have been introduced, which you can see on the slide, making it a lot easier for the Office of the Information Commissioner to address non-compliance without court proceedings. Previously, civil penalties were only available for serious interferences with privacy, which required a very high threshold. They may issue an infringement notice for minor breaches. If the person doesn't comply, then fines may be up to $330,000 for corporations or $66,000 for non-incorporated entities. Some examples of low-tier offences, which are provided by the officer's explanatory memorandum, include failure to have a compliant privacy policy. And honestly, I talk to health professionals on a weekly basis who don't know that they need to have a privacy policy. So I just want to ring the bell on that. We do. Everybody needs one. You can't get out of not having one. And you can now get a fine of up to $330,000 if you have a company for not having a compliant privacy policy. Failure to provide written notice of certain uses of or disclosures of personal information. So that's if you have a breach and you don't follow the mandatory notification requirements. Failure to provide a simple means of opting out of direct marketing communications. That may or may not apply to you in your practice. Many practices don't do direct marketing, but as time has gone on, more do. So having that ability to opt out is critical now. Mid-tier offences cover general interferences with privacy, which do not amount to serious interference. For example, where an organisation fails to notify individuals of an eligible data breach as soon as practicable, the explanatory memorandum notes the mid-tier offence was introduced to safeguard organisations from misusing personal information and for unrelated commercial and competitive purposes. The penalties for mid-tier offences are up to $3.3 million for corporations and up to $660,000 for individuals. Penalties for high-tier offences remain the same following these reforms, and that is up to $50 million or 30% of the entity's turnover, or 3 times the benefit obtained from the breach. An example of a serious offence includes unauthorised and unintentional disclosure of highly sensitive medical records or intimate photographs. Again, these penalties came into force on the 11th of December 2024. The Children's Online Privacy Code has also been something that the Office of the Information Commissioner is being tasked with developing to enhance protections for minors. This means that if your practice engages with paediatric patients online through telehealth or booking systems, you'll need to monitor updates to ensure compliance with age-specific compliance requirements as well for privacy. The code is going to be developed by the 10th of December next year, so it's just something to keep an eye on in this sector. Now, something someone else asked me about recently, which is relevant for us, but not relevant for everyone. So I won't spend a lot of time on it, but there are relevant requirements in every other jurisdiction as well. So take note. Western Australia recently introduced the privacy legislation, which is the Privacy and Responsible Information Sharing Act 2024. And this applies to WA public healthcare providers, but it can also extend to private practices that contract with them, which many private practices have contracts with public health providers. So if you're based in WA and you provide services under a state services contract, your practice may be required to comply. Please do note that the Commonwealth Privacy Act doesn't apply to state and territory public sector health service providers like public hospitals, but most Australian states and territories have their own equivalent legislation which covers their own public sector agencies like this Act. Under this new legislation, affected organisations who are known as IPP entities must follow 11 information privacy principles. These principles set the rules for openness and transparency, being clear with patients about how their information is being used, collection and use, ensuring information is collected fairly and used only for the purpose it was gathered, anonymity, giving patients the option to remain anonymous where practicable, disclosure, storage and handling, limiting disclosure, keeping data secure and managing it responsibly, de-identification or destruction, making sure information is either properly de-identified or destroyed when it's no longer needed. What does this mean for you and your practice? Well, I'm going to break it down into 5 key actions for you. Firstly, Review how you collect, store, and share patient data. Make sure every step is lawful, necessary, and secure. Second, update your consent forms and patient communications. Consent must now be informed, specific, and current, and your patients should clearly understand how their information is being used. Thirdly, ensure your privacy policy reflects the reforms, including the increased obligations to technical and organisation measurements. If you use automated systems to make decisions, understand that this needs to be fully disclosed in your privacy policy. Fourth, train your staff. Many privacy breaches happen because of human error or lack of awareness. Make sure your staff know how to handle information properly and how to respond if something goes wrong. We at YouLegal regularly do phishing tests to make sure that our team know how to respond to an email that's a bit suspicious or might be hacking into our systems. So doing something like that regularly can be really quite easy to set up through different systems that you use, and also can be very comforting when you get feedback that no one clicked. So that's something that I do in my business and recommend. And finally, I've put strengthen your systems. So putting in strong cybersecurity measures and having a clear data breach response plan that people are trained on, that's ready to go, can really help protect your practice and really help owners with that sleep at night factor, which we know is important to you all. So how do you actually reduce the risk of a data breach in your practice? Well, here are some measures that you can take. First, use encryption and secure storage so patient data is protected even if your systems are compromised. I know of a practice who did not have this. They were a specialist dental practice, and somebody did click on an email that was malicious, and the bad guys locked down all their systems. They didn't know when their patient meetings were. They didn't have their information, and so not only was that embarrassing for the business to keep operating on, but then these bad actors asked them for a money in terms of a ransom to release the information. And of course, when you're dealing with criminals, it's very difficult to know if you pay them the ransom that they're asking for, if they're actually going to release it. So it's a very difficult situation to be in for practices, but these steps can really help prevent that sort of emergency situation that I'm talking about. Secondly, implementing access controls, only having the right people having access to sensitive information and only when they need it. Third, keeping up with regular system updates and patching. Many breaches happen because of outdated software. So you're paying for the software, make sure you update it on a regular basis. Remember that staff awareness is your first line of defense. Training your team to spot risks is often more effective than any piece of technology can be. They really are the first line of defense. And finally, have a response plan ready to activate immediately. The faster you can contain and respond to a breach, the less harmful it will be to cause to your patients and of course your practice and your reputation and your ability to operate. The example I gave earlier is one that just made it impossible for them to operate for the time that it took to resolve that issue. So those of you who know me and have come to these webinars before know that really protecting your practice, not dealing with disasters, is the area that I really focus on. Getting privacy right isn't about avoiding penalties or just avoiding penalties. I'd certainly want you to avoid penalties. It brings real benefits to your practice. I see it as an insurance policy for your practice as well. It's money that you well spent upfront that means that you know what to do in the case of difficulties, and you're avoiding those regulatory costs that I talked about earlier. It also protects patient trust, which is the foundation of your business and every healthcare relationship. It reduces the risk of costly breaches and penalties, saving money and stress. It ensures regular audits and accreditation, and regulator checks are smoother. You've got the documents, you know where to find them. It strengthens your practice's reputation as a professional, reliable provider, and you know it's up to date because the law just changed and you've just done this. Ultimately, it positions your clinic as a safe and trusted place for care, which is a real advantage in today's competitive healthcare environment. Here's a case study from a client that we had to work with, unfortunately, a little bit later than we usually prefer to work with clients. One of our clients had a patient file stolen from a car. They had a hard copy file, which is unusual in this day and age, but they were visiting clients in person because of the nature of those patients. It's really an example of what can happen. So that's firstly horrifying. I know anybody who's listening is feeling horrified, I hope. But it's really an example of what can happen when privacy obligations are overlooked. Our client was a small healthcare practice and they hadn't reviewed their privacy policies or staff training in years. There was no clear procedure for transporting or securing physical patient files outside the clinic. Unfortunately, the practice experienced a serious data breach when a staff member left a patient file in their car, which was later broken into and stolen. Because the practice's policies and systems were outdated, they didn't have a proper breach response plan in place. The result, the regulator launched an investigation which was time-consuming and stressful for an already busy practice. The breach became known in the local community, causing serious reputational damage. Some patients even left the practice saying they no longer felt confident that their personal information was safe. The costs of managing the fallout, including legal fees, IT fixes, reputational repairs, it far outweighed what it would have cost to keep their privacy framework up to date in the first place. The key lesson is simple. Updating your privacy systems costs far less than managing a breach. Proactive compliance protects not only your patients, but also your practice's long-term stability. So to conclude, these privacy reforms really impact every medical practice, no matter your size or location if you're based in Australia. That's why it's critical to start reviewing and updating your policies and procedures now. Don't wait for problems to surface. Put the right protections in place straight away. And remember, compliance isn't just about the legal requirements. At its core, it's about safeguarding patient trust. Because ultimately, when you protect patient data, you're protecting your practice, its reputation, its people, and its future. So here's your next steps, because I know that you want to ask me what you should do next. Firstly, review your current privacy framework. What policies and systems do you already have in place? What are some potential gaps? Do you have a mandatory notification framework in place? Have you done training for your staff on it? Secondly, seek professional advice for policy and procedure updates. Privacy law is moving quickly, and having the right advice ensures that your policies are accurate and compliant. Third, consider a privacy health check for your practice. This kind of review gives you a clear picture of your risks and the practical steps you can take to strengthen your practice and the protections for your practice. If you'd like any help with these, feel free to email me or book a call with myself or one of our senior lawyers. We also have fast track solutions, and I recently did a podcast with someone and explained that we try and keep it as simple to engage us as we possibly can. And if you have a look at these online solutions or fast track solutions, you can see the scope and how we do that by not taking too much of your time and making it really as straightforward as we can. So we have a fast track solution for a privacy policy, a fast track solution for a notifiable data breach package, which will include all the letters and everything you need if you do have a data breach. So you'll be ready. You can train people on that. You also have an AI policy, which I'll put in the email that I send around as well on our fast track solution page, which I really think is probably critical to managing some of the issues that are coming out of people, practitioners using AI in your practice, which overall as a practice, you might become liable for, even if the practitioners are paying for it themselves. All right, I'd love to hear your questions. You can pop them in the chat or unmute yourself if you like. There's a booking link for me there. Thank you for joining. We're at time, but I am going to take questions, so you can hang on if you like or watch on the replay. But privacy law is very important. It can have very real consequences in our industry. So if you'd like to talk further, this is how you can reach me. I hope you do leave today's session with some clarity and confidence on your next steps. Also, if you don't know about it, we've got a Facebook group. It's called You Legal for Doctors. You Legal will welcome doctors and allied health professionals. There'll be some questions that we ask you on your way in, but you're very welcome to join. Now, there seems to be a lot of questions. Sorry, I should know this. We'll send out the slides for you for sure, Philippa. So Philippa says many contracted doctors use their own computers, laptops versus practice. Do they bear the risks, not the practice? I think the answer to that probably is it depends, Philippa. They will have risk, of course, as independent practitioners, and the practice will also have risk if it's the same practice management system that you're using. And if everybody's using an AI transcribing tool, that'll be both the practice risk and the practitioner risk. But if they're just using it, that AI risk is theirs, but it can also be yours in the notes that it takes. Nicola's heading off. Thank you. All right, some people dropping off. Natasha, can you touch on the implications on AI in the privacy policy? I can. There are certain aspects of your privacy policy that are going to need to be addressing your use of AI and how you use it, which is why I do suggest having a policy. We've got a policy in place. All right, where is my answer to this? Because I did anticipate your question. Let me open it here. Oh dear. I'm going to stop sharing. Here we go. Regarding AI. So where it's relevant for privacy policies is really in the transparency obligations. It needs to be disclosed in your privacy policy. Security and due diligence, so ensuring that the AI meets your organizational requirements, and then also really understanding the enforcement and penalties. So there's stronger investigative powers now. So if you fail to properly record things, that would be a potential breach that the regulator would look into. All right, let me have a look. Are we responsible for independent clinicians? Pia, it depends on what your arrangement is with them. We can always have a look at that as a draft, well, as a kind of an engagement to see what privacy obligations the practice has. If you're a GP clinic and you have accreditation, you certainly will have responsibilities in relation to privacy in the practice. Kate says many specialists still send us patient letters by email with any. So you they will have the primary responsibility. Do you have any responsibility is your question, Kate? You will not have the primary responsibility on that. that is really the way that they're running their businesses, and they're taking risk on that. How do you access training for staff, Janine? Good question. We do training for staff as part of our services in relation to privacy and procedures, and I'm sure that there must be other opportunities for privacy training in health as well. Maybe look at your PHN. They might have some offer as well. All right. Carolyn says, what are the implications on the new privacy laws with patients gaining access to their own records? Yes, Carolyn, they certainly now have the ability to do that. And I think the way that you would deal with it is making sure that you have a policy in place in relation to that, and also that you have proper fees that you're charging for it, and making sure that you identify them properly before giving any information, and that you're giving it in a way that you're comfortable complies with your policies and the laws. Kaylee says, could you explain a bit more about what automated decision making refers to? Sure. So there are some practices using AI tools that maybe make automatic decisions in relation to patients, in relation to people who contact you. And so it might not be relevant for your practice, Kaylee, but if you're doing it, you probably know. It is what I would say, and that needs to be captured properly in your privacy policy. Sandra says, Sarandra, sorry, says more and more lawyers and insurers are asking to email records. Well, you should have a look at what your responsibilities are in relation to that, and making sure that you're comfortable with the way you're doing that, and that it complies with the law, and that it complies with your own risk management framework, I think, because this is a lot about risk management and what you're comfortable doing, as long as you're doing what you must be doing under the law. And it might be that you have a secure link that you send out that they need to download it from using passwords. I know that my GP clinic does that with certain things, and I have to put in a password that they send me separately. So that's my answer on that. Should we differentiate between AI scribing and AI actual decision making? Yes, that they will be two separate things that you'll need to consider as part of your privacy framework, Ian, for sure. Linda, what do the rules with regarding a patient's electronic records within the appropriate time? I think that is a great question, Linda, and it's something that is different in every state and territory. So it's something that you should definitely get some advice on, because there are different requirements in different states and territories, and there are also different requirements in relation to medical records and digital records. So getting some proper advice on that is going to be worth the investment, I think. Because also, I think the other thing is that different businesses keep a lot of information that they don't need to keep, and that can increase your risks. So that's why it's a good question, but we don't necessarily want to be deleting patient information that we shouldn't have, and then somebody comes looking for it. Demelza, I'm not aware of any free training that you can offer to admin. Have a look on the website for the Privacy Commissioner. Maybe they have some that would help. It's most relevant if you can have training that's really tailored to your organization and relevant to how you deal with things, rather than just generic training. Probably there are a few different privacy trainings on our website for our on our webinar page, so you could have a look at those, but this will be the one that's the most up to date. Jenny Lee, what about third-party booking systems? 100% you need to be looking at their privacy policies when you engage with them, and on an ongoing basis, because the privacy obligations will continue to be relevant. So maybe if you need to update your privacy policy now, you should be looking at their privacy policy, because it's interesting when there's a breach, isn't it? The breach is, if somebody breaks into your house, people always blame that criminal. But if someone breaks into your business electronically, whether it's through the use of a third-party platform, which Medibank, for example, was, people always blame the business, not the hacker or the criminal. So it's 100% a brilliant question to be asking, Jenny, and something that everyone should be aware of. Kim, yes, you're right. Big responsibilities. Thanks for your comment. Chantel, we've just had an email security breach. At the time, our IT company immediately changed passwords, rules of two-factor authentication. Is it compulsory of the Privacy Commission to have an extended cyber security investigation at a cost of $10,000? Chantel, I'm not sure what information was lost. You'd be working through your privacy mandatory breach notifications to see what's required based on what information was lost. But it might be that you need to notify people. There are different requirements for sure, and I'm not sure with the information you've given whether that you're required to do that $10,000 review. So definitely worth looking into. Carolyn said the Office of the Information Commissioner does free privacy education. So that's great. If you can find something that's tailored to health, I think that also would be a big tick towards you as well. Catherine says, when a practice receives information from specialists, it quite often states this is not for disclosure to third parties. However, once we receive it, it becomes part of the patient's record. Are we allowed to include these in record requests? That is a good question. So those records will be kept under the patient's notes. I think it would be a decision for you to make at the time. If I think it probably is information that your practice could keep, because it would be reasonably relevant to that patient, but it's something you'd want to think about and look into for sure. Han says her clinic is comfortable emailing patient records files without password protection. Is that okay? Han, it's really a matter for you and your business. It's something to get advice on, maybe, if you want to know if it's okay under the law. And if you are like, I guess some doctors have asked me if I'm okay with it before they do that, rather than just assuming it's okay. So definitely something to look into. Oh, there's one in the Q&A box as well. An anonymous says, many specialists who, oh, no, so they've asked that one before, so that's great. Well, I've run over time because there were so many questions, but thank you so much for coming along and staying. Thanks, Deanna. Thanks for coming along. And it's great to know that there's so many people interested in this topic, and also that you're wanting to protect your practices, because that's something that makes me just so happy and absolutely worthwhile, all the time and effort put into a webinar like this. We'll send you a recording of this so you can send it to people who you think might benefit from it. We'll send you an opportunity to book in with me or Daniela, one of the senior lawyers in my team. Kate, you can ask one more question. I thought you weren't going to be able to make it because I think we've been emailing, so I'm very happy to see you here. Ask the question and then I'll wrap it up. And for those of you who can't stay, I'll check you next time. And I mean, if you're still there, also feel free to reply to my email to let me know what sort of topics would be useful next month, because I do this every month. And it would be helpful to make sure it's relevant to you and what you're thinking about. All right, Kay, I'm sure you're furiously typing. I'll wait for your question to come through. Thanks, Mervat. Thanks, Sue. Thanks, Deanna. Thanks, Prasanga. Oh, Teresa, yes, you'll get an email with the copy. No worries for being late. It'll probably come out tomorrow, I think. The recording takes Zoom a little while to send it to me. All right, Kay. When it comes to the statutory tort and needing to confirm patient ID for accreditation in the waiting room, Is there a specific question you should be asking or mindful of? It's a good question because you don't want to be identifying people properly. Sometimes in practices, you always identify them um, at the reception, but I'm not aware of any particular question you should be asking. If it's more an accreditation question, maybe ask your accreditation body based on the privacy updates. I think it would be good to know what they say. Um, and on that note, I will wrap it up and we'll be in touch, I'm sure. Thanks for staying, everyone. See you next time.